My name is Steve Shupe. I'm an attorney in the Sonoma County Counsel's office. And I first got involved with CCAs because the water agency is my client. And when this idea was sort of first brought to my attention, I sort of had the same reaction a lot of people have, which is, why would you want to do this? I mean, I was probably one of the most skeptical people in the county when it came to this idea at the beginning. But as I started to work on the project more and more, as the feasibility study got done, and I really was able to dive into that and see what the advantages were, you know, I became a real true believer. So my advice is that you need somebody like me. And I'm not necessarily me, but you need a skeptic on your staff. You know, you need to have at least one person there who you're going to be able to go to, who's going to be able to give a hard look at what you're doing. Because if you can convince that person internally, you're way ahead of the game in terms of convincing people outside. So I'm going to talk about two different things, and my handout, I think you've got it. I'm not going to put it up here because it's kind of long, but I'm going to talk about two different areas. One is governance issues, and one is risk. I want to start out with governance issues, and there's kind of two aspects or elements to the government issue. One is, what kind of organization are you going to set up in order to run your CCA program? And the second is, if it's a JPA, which it typically is, what kind of governance structure do you have within that JPA? How's it actually going to be governed? As to the first issue, the big advantage to setting it up, you can do a CCA program, I think, in principle, just under one jurisdiction. So under the statute, a single city could set up a CCA program like San Francisco is proposing to do. We didn't feel that was a prudent idea because you run into this risk of having the liabilities of that enterprise potentially the city's general fund being at risk for those. And that was something that we wanted to avoid. The way the JPA law in California works, if you set up a JPA, you can put in your JPA agreement that you're setting up a separate legal entity and that the liabilities and debts of that separate legal entity are not imputed back to the members. So that means essentially you can run the CCA program without any risk of the city's general funds being hit for any of their liabilities. And that was a big selling point for us because essentially we were able to say to the cities we were trying to get to participate, you don't need to worry. You know, you're not going, your own dollars aren't going to be on the hook. I also think, again, the disadvantage of setting up a JPA is that you have to end up doing a lot of negotiations with cities, number one, to convince them to come into the JPA. We have that problem, that challenge in Sonoma County. And number two, then, if they do come in, you have to figure out how it is that you're going to set up the governance structure of the board. One thing I did want to say, which I disagree, I think it was Sean brought up this point about apparently there's a CCA who's going to allow for the possibility of revenues from the CCA being used for general government purposes. We particularly didn't think that was a good idea. One of the things that one of our points that we made when we were going out and talking about the CCA was, this is not going to result in any more taxes on the one hand. This isn't a taxpayer-funded program. It's funded entirely from rates. So it's not going to be any new taxes. That was half of it. But the other half of it was ratepayers aren't going to be ending up being subsidizing general government. And we felt that was a very sort of clear line that we needed to hold. On the governance issue, the biggest thing that you'll face, and you'll see this, I think, probably as you move on, is there's big problems when you have different sized jurisdictions. The bigger jurisdictions obviously want to have more say in the governance. The smaller jurisdictions are worried that they're going to get rolled and not have enough say in the governance, and you're kind of faced with this problem of how do you balance those, how do you balance those two things out? If you have a one member, one vote structure, that really favors a smaller jurisdiction. The alternative is sort of have a pure weighted voting, which would be based on the load that's being served within jurisdictions, but that means that one or two sort of bigger players, in our case anyway, could sort of set policy for the entire board, and the smaller jurisdictions wouldn't have a say. So what we ended up landing on was kind of a hybrid system, and this took a lot of negotiation to get through, but we now have a board that's comprised of one member from each of our participating jurisdictions. It can be, but it doesn't have to be an elected member. So a city could decide to, put their public works director on the board if they wanted to. And the rule is that most votes are simply done by one board member, one vote. That's kind of the default. Each board member gets a vote. But any single board member can call for a weighted vote. So if, for example, the city of Santa Rosa wanted to call, they're our biggest jurisdiction in our JPA, wanted to call for a weighted vote, they could. Once that weighted vote gets called for, then it requires both a majority of the actual number of board members and a majority of the weighted vote. It's a double majority standard, which actually it's worked well so far. We've never had a call for a weighted vote. All votes so far have just been on this kind of default method. And if you do have this double majority requirement, it really kind of pushes people towards consensus, and that's something that we really wanted. So that's sort of how we found our way through that problem. Wow, I'm going faster than I thought. We did have some occasions where we had special voting requirements. We have a special requirement for if there's an amendment to the JPA, it has to be a 2/3 vote. And then we had a special thing that some of the smaller jurisdictions wanted where if something could be defeated by one member in a weighted vote, in other words, if one member had more than 33% of the weighted voting power, that one member could not defeat something. They had to have at least one other jurisdiction come in with them. Again, this was an attempt to protect the smaller jurisdictions. I'm glad Jeff isn't here. The one sort of mistake that I think that we made, and I have to say it was probably me more than anybody. I had drafted the JPA to set up 2 standing subcommittees that were required under the JPA. And this in part was to meet some of the criticism that we heard from some member of the public that, well, if you're setting up the CCA and the primary purpose of it is going to be, greenhouse gas reductions and climate change, fighting climate change, what about the ratepayers? How are we going to know that the ratepayers are going to be protected? And so to kind of bake that into the JPA, we set up a requirement in the JPA that there be a ratepayer advisory committee created that would be appointed by the board of directors, and that all rates and budgets of the CCA program would be have to be approved by the ratepayer advisory committee. It sounds very good in practice. Excuse me, in principle. It hasn't worked out that well in practice. In part because there isn't a sharp division between what constitutes rates and budget and what constitutes all of the operations of the system. And the ratepayer advisory committee, kind of rightfully in my view, is saying, well, you can't just come to us at the end of the day and say, well, here's our budget and here's our rates. If all we can do is approve it, say yay or nay to it, and it's just advisory anyway, why are we really here? And so my advice would be to people, if you're going to set up a JPA to do this, not to set up any standing committees that have to be formed under the JPA. Leave that to the board. If the board decides that they want to have an executive committee or some smaller subgroup, or if they want to set up a ratepayer advisory committee, do that. But I wouldn't bake it into the JPA. I think in retrospect that was a bad idea, and again, it was probably mostly my fault. The other thing I wish I'd done sort of better early on is, and this came as kind of a surprise to me. Why I don't know. I should have thought of it, but most of you here are working for cities, right, or water districts that have been in existence a long, 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 long time. And you have this whole sort of administrative structure that's already available to you. When you've got a new entity that you're setting up like a JPA, you don't have any of that. So, we went to hire our first person, which was Jeff, the famous Jeff Cyphers. And we realized, well, we don't have we don't have an employment resolution. We can't hire anybody. We don't have any HR standards. We don't have any personnel policies. We don't have, there was a ton of stuff that a startup needs to have, that a public startup needs to have, that you don't, and I would go to other, I work in an office of 27 lawyers, and I'd go to other people in my office and say, has anybody ever done this before? Well, no. right? The county's been in existence for 150 years. Nobody there has ever had to do any of this stuff. So think about that ahead of time and get some of your city HR and other people involved in that ahead of time, because it caught us a little bit flat-footed when we went to startup. We sort of had to really scramble to put all these structures in place. Another thing that came that was difficult for us was this whole thing. And the California finance law, public finance law, is very sort of archaic and old-fashioned, those of you who deal in it. Every organization needs to have a treasurer, right? And we, typically in a JPA, it'll say, well, the treasurer is the treasurer of the county. You use the county treasurer as the treasurer, and that's typical. The problem was, in this case, it didn't really work that well because of the way the financing. Jeff was talking about this account that they had at a bank in order to secure repayment to the energy suppliers. Technically the treasurer is supposed to have a hold of all of the funds of a public entity. And so that's another thing I would encourage you to talk, when you set up your JPA, have a talk with your treasurer, your county treasurer, or your internal accounting folks about what's the smartest way to set that up, given all of the things financially you're going to have to do in order to run your program, including buying power and providing security for it. So that's sort of a background on governance structure. JPA is probably the way to go. You're going to have some negotiations over kind of how voting goes within the JPA, but you'll get to that. Try not to let it derail you too much, though. What we finally ended up doing, and Cordell was very good about this, we ended up just setting a deadline for the cities, saying you either come in by this date or we're going forward without you. And I personally thought that wasn't going to work, but it worked really, really well. And all the cities that came in the first time ended up coming in by the deadline, or maybe just a little bit afterwards. So I want to move on now about risks, because there are risks attendant to starting up a CCA program. And I share whoever said, maybe it was Jeff, it's very, very important that you communicate the risks. When Cordell and I went out and did our sort of dog and pony shows at the city council, he would say all the great things that CCAs could do, and then he'd turn to me and let me stand up and say all the bad things that could happen if you had one. But that worked because people needed to know that you'd thought about the risks. It's a very, very important part of it. Having said that, I just want to point out one thing, because people have talked about the complexities of the electric market and negotiating power contracts, and the wholesale power market is so technical and blah, 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 blah. And that's true. All that's true, and I don't want to undercut that. But when you think about it, at base, this is a really simple business model, right? You're buying at wholesale and you're selling at retail. I mean, it's old, right? That's an old thing that people have done for a long time. That's number one. Number two, how many businesses get to start up with basically a given customer base? Here's 80% of the electric customers in the county. You want it? It's not that hard or difficult when you think of it in those terms. So anyway, but I do want to talk about some of the risks. There are a number of different kinds of risks. And a lot of them do have to do with the power markets. Number one, you have to match supply and demand. You set up a CCA program, you take on the obligation of providing your customers with power every minute of every day, all through the year, all right? That means you have to go out and buy power to try to estimate what those demands are going to be at every minute of every day of the entire year. If you misjudge that, right, you're going to be in a situation where you might not have enough power to serve them, or you might have purchased too much power to serve them. In either one of those cases, there's a market risk that you bear. You're going to have to buy some power to make up for the deficit or sell the power that you overbought. And depending on what the market's doing at that time, you can have a loss or potentially a gain on that. But that's one kind of risk that I call sort of estimation risk that you have to deal with. There's also inherently in any sort of market, kind of market price risk over time, right? I can enter into a contract right now for power at $60 a megawatt hour. Okay, that contract can go out 3 years, which means 3 years from now, if somebody delivers me power into that contract, I have to pay them $60 a megawatt hour. Well, guess what? If the market price at that time has gone to 40, that's not good, right? Because now I'm in a situation where I'm buying power and delivering it to my customers at a price that's way over the market price. And again, that's another risk that's just inherent in getting into this business. The way you deal with it, it's the same way you deal with risk when you're investing in your own private portfolios. You diversify, right? You make sure that you don't just have one contract that goes for a long period of time. You layer your contracts. 5 minutes. You get different suppliers like Jeff was talking about. You make sure that some of your power you're going to get on the spot market. And here's another thing that's important. When you set up your contracting strategy, you want to make sure that the consultants that you have realize that you need to make sure that you're always within striking distance of PG&E. Because the real risk to a CCA program is that your generation rates are going to get way out of whack with PG&E's rates. That's really the bottom line risk. As long as you're within striking distance of PG&E, you're probably going to be okay. Because once people have not opted out of your program initially, there's a great deal of inertia, and you're probably not going to get a lot of people opting out after that time unless you really get a pretty big delta between your rates and PG&E's rates. There's also 2 other risks I want to talk about. One of them was mentioned before. I call them regulatory risk. You know, the electric industry is highly regulated by the CPUC. A lot of what goes on at the CPUC will affect the price that the CCA the rates that the CCA has to charge, and also PG&E's generation rates. You've got to make sure, and CCAs I think are just starting to kind of get more involved in this, make sure that that system doesn't get gamed by the incumbent utility in their favor. So but that is another risk that's out there that you really can't avoid. The final thing I want to talk about is sort of the worst case scenario, because people always talk about this, right? Well, what's the worst thing that can happen? The worst thing that can happen if you set up a CCA program. It turns out that the worst thing that can happen is not really that bad. The worst thing that can happen is that all these market risks go against you, right? You end up being in a situation where your power costs so much that the rates that you have to charge to your customers are significantly higher than PG&E's rates. What's going to happen? They're going to go back to PG&E. Then what happens? You have even less money to pay the overpriced power that you bought, right? And it becomes a spiral. And at some point, you get to the point where the CCA doesn't have enough money to pay off all of its debts, and it has to go bankrupt.
That's why it's a JPA.
That's why it's a JPA. Thank you. What happens if the CCA goes bankrupt? Well, you have to put up a bond. The bond was talked about earlier in this presentation. You have to put up a bond to basically take care of the eventuality that your customers go back to PG&E. CCA goes out of business, and basically that's what happens. Your customers get put back to PG&E. They go back and they get PG&E rates, okay? Your suppliers may be out, right? The power companies you've contracted with are probably going to lose some money on the deal. Your elected officials and staff are probably going to be a little embarrassed by the fact that they set up this thing that went bust. But at the end of the day, really what you're left with is the status quo. Your citizens, your residents are back taking their power from PG&E. So the worst case scenario isn't really that bad. It's also very unlikely to happen. I can tell you after looking at the feasibility study and sort of the economics of this, it's very, very unlikely that that's going to happen. I mean, the chances are really, really minuscule. But even if it does, the worst case, isn't that bad. So, in conclusion, I just want to tell you one thing that we, do I have time? Yeah. Okay. I just want to tell you one thing that we came up with when we were doing our presentations. We called it the Triple Firewall. I called it, it was actually my term. Not cipherish, I know, but we called it the Triple Firewall. How to protect cities from the risks attendant to a CCA. And we had, in the Triple Firewall was 3 levels. Number 1, the JPA structure immunizes the cities from having liability for the debts of the JPA. That's number 1. Number 2, we promised the cities that in every single contract that we did, we would put a clause in it that would essentially tell the counterparty, you agree and acknowledge that the only thing that you can look for repayment of any debt under this agreement is revenues from the CCA system. An explicit, basically, disclaimer of any right to go back against any of the members of the JPA or any customers of Sonoma Clean Power. And the third level was, because we've had some cities that were still a little bit skittish, Cordell mentioned that when we set up our JPA, we had it only between the Sonoma County and the Sonoma County Water Agency. We didn't even require cities to actually formally join as members of the JPA. We just said, if you will participate in the program and let us serve residents in your jurisdictions, you can have a vote, you can have a seat on the board of directors, but we're not even going to require you to formally sign on to the JPA agreement. So, you know, how is somebody going to ever come after your general fund if you're not even formally a member of the JPA? So between those three levels, I think we were able to convince cities at the end of the day that they were pretty safe and that their general funds weren't going to get hit by the CCA program, even if the worst were to happen. That is it.
All right.
We're done.